Give it appearances, please. Good morning.
Your Honor, I'm Joseph Thomas. I'm the plaintiff, Brian Cortland.
Good morning. My apologies. It appears the lectern is off, but it's absolutely fine. Don't worry about it. My apologies for the inconvenient spacing in this courtroom this morning. I've reviewed the reconsideration motion, and my initial question to Mr. Thomas is that upon initially reading the complaint in this case, my understanding was that the main thrust of this case was not that there were documents that existed within Lewis County somewhere that were withheld, and not that in toto Lewis County failed to do a search, but that specifically the Law Library Board didn't do the search and the Law Library Board didn't turn over the documents. My question to you is that, is your complaint, should we be construing that to be questioning or attacking the sufficiency of the documents turned over overall without regards to this who is the Law Library Board question, and is it attacking the sufficiency of the search without reference to that question?
Yes, Your Honor, it is attacking the sufficiency of the search, and I believe that the record would show from the previous hearing that I did argue that the search was incomplete, and we believe that records were being withheld.
Okay, so you believe that there exists within Lewis County responsive records somewhere, actual documents that you should have been given but were not given?
Yes, Your Honor, we believe we don't have proof, but that falls upon Lewis County in order to fulfill that burden of proof, and they failed to do so. In fact, if the court looks at their reply in the summary judgment hearing, they said that the facts are not in dispute. They said that no search was, they didn't have to do a search, they turned over the documents, and that they waived this argument. In fact, we brought it up again during the motion for reconsideration, and they failed to address their burden. They have a mandatory burden to show that a search was performed, an adequate search was performed under the Public Records Act. They can do that by declarations or by other evidence, but they didn't do that. The proof is beyond material doubt, and they needed to fulfill that burden. They waived that burden, and I think that's the end of the story.
Mr. Carter.
Thank you, Your Honor. It was my understanding that it was an argument of legal sufficiency after I saw that was in the complaint. Again, I made a mistake in the last proceeding saying that wasn't there, and I apologize for that. But the argument...
And I think there's no need to apologize. I saw that there was a search referenced. My understanding from looking at the complaint was that the search was an entity that doesn't exist, couldn't do a search, rather than there being a general lack of sufficiency of the search. So I was on the same page with you after reviewing
Your Honor, I don't want to belabor the point, but I agree with you that the motion, the response to the motion made the same argument. The argument was that Lewis County never performed a search, that the agency is required to do a search, and in this case, the agency is either the Lewis County Law Library Board or Lewis County. The argument was that he also argued that Lewis County did not perform a search at all, and that isn't true. In the record on summary judgment attached as Exhibit B to his response are the interrogatory answers where how the search was done is presented. It states in the answers, which are verified by Susie Parker, the court administrator, that the Superior Court PRO, Ms. Susie Parker, directed the search warrant provision of responsive records enlisting, for example, the assistance of the Information Services Department in searching electronic records. She also reviewed the physical records in the court's possession and control. As for electronic records, Information Technology Services made the documents accessible from the computer provided by the prosecutor's office to Mr. Carter as Chief Civil DPA. There is evidence there as to the factual sufficiency, but Your Honor, I do agree with you. I understood it to be an argument of the legal sufficiency of whether we have an appointed PRO under the PRO. If in fact the court construes it to be one for the factual sufficiency, then that's something that, if you don't believe that that has been adequately briefed, then I understand the request of the court to go to further briefing.
Thank you. And Mr. Thomas, I don't need to hear anything else. I'm going to grant your motion for reconsideration.
Thank you.
And so let me identify where we stand right now, though. I had construed the complaint and the briefing to be focusing on what, I don't know if it's the proper term, but I agree it sounds like a reasonable term, the legal sufficiency. Given that there wasn't a public records officer assigned for this entity that doesn't exist, and basically the legal technical identification of who is doing what. Those issues are no longer part of this case. The fact that there isn't a law library board, and thus any documents were, and who the return address was associated with when documents were provided, and who was doing the search, those matters are not in this case anymore. There's still, I think we are a notice pleading state, and I think fairly construing the complaint, I cannot say beyond a reasonable doubt, which is the standard for construing complaints, that there isn't a claim there that documents exist that have been withheld or that the search was insufficient. I would caution counsel that, as I'm sure you are well aware, you cannot simply file a lawsuit and make the other side prove it. You have to have a good faith basis under fact and law under Rule 11 for believing that there are some documents out there that exist and that the search was insufficient. And that issue isn't squarely before me right now. I just want to clearly articulate that there is some obligation under the rules of professional conduct and the civil rules for meeting some initial burden for your obligations associated with any lawsuit, whether or not that is a PRA case or something else. But again, that issue isn't before me. I'm going to grant the motion for reconsideration, which should simply say the motion is granted and should reflect that all issues associated with the identity of who was producing the documents and who was conducting the search are dismissed with prejudice. All remaining claims are not dismissed. And I would ask the parties to confer regarding a date that makes sense for us to set a merits hearing for that final issue and a briefing schedule associated with that.
Your Honor, if I may clarify for the record, this has already been brought up, and this is a mixed issue of law and fact. And if I may draw this court's attention to the Neighborhood Alliance case, the Neighborhood Alliance of Spokane County versus the City of Spokane, or the County of Spokane. The site is 261 Pacific 3rd, 119 at page 128, and that's a state Supreme Court case from 2011. Quote, the agency bears the burden of beyond material doubt of showing that the search was adequate. To do so, the agency may rely upon reasonably detailed non-conclusory affidavits submitted in good faith. The problem is that this court talked about CR11 sanctions. Mr. Cortland could only assert a belief because he doesn't know what records that Lewis County contains, and that's an unfair burden to place upon him or upon me as his counsel. And the case law is very clear that this is a mixed question of law and fact, and that Lewis County has the burden to prove as a matter of law and as a matter of fact that they performed an adequate search. And even Mr. Carter recognized that the interrogatories show that only the court performed a search. We asked in the interrogatories who performed a search, and we did our due diligence in discovery to figure out who performed the search, and only the court performed the search. And the Neighborhood Alliance case is very clear that the agency bears the burden of showing that its search was adequate.
Okay, thank you. I mean, I didn't want to suggest that I was believing any action was sanctionable here. I do agree with you, obviously, that the Supreme Court said what it said. It doesn't obviate anyone's obligations before initiating litigation to fulfill other obligations. And so we'll leave that at that, and we will deal with this when we get there. And your motion is granted, and I will sign an order that can be submitted ex parte. Hopefully there won't be any issues about the form of that order because, again, as I said, it should simply say that the motion is granted. Any claims associated with the identity of who searched and who produced records are dismissed with prejudice. Any other claims in the complaint are still alive.
Thank you very much.